Hey everybody, welcome back to This Week in Immigration. I'm Jordan Lapierre. This week, abolish ICE inside the rallying cry, the government's progress in reuniting separated families, and explaining the process of denaturalization, or when the government can revoke someone's citizenship. All that and more coming up. But as always, remember, subscribe, rate, review, and share this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. You can also stream on our website at bipartisanpolicy.org. And while you're there, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. So let's get right into it. Here today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy and fresh from a vacation. Hi, Theresa.
Hi, Jordan.
Cris Ramon, Policy Analyst.
Hey, Jordan. How's it going?
And Tim O'Shea, Immigration Intern.
Hi, Jordan. How are you?
Hi.
This
Welcome
week
to
in
the show.
Immigration debut.
So let's start, though, with a hashtag that's become a policy movement, abolish ICE. In the last few weeks, we've seen a range of Democrats, such as Senators Kirsten Gillibrand, Kamala Harris, and Elizabeth Warren, call for the abolishment of ICE. So let's start with where this policy came from, this policy demand came from, and why some Democrats are beginning to embrace this call to end the agency, Theresa.
Well, the hashtag abolish ICE has been around on social media for many, many months. And I think it was started by grassroots immigration advocates in response to the ramp up of immigration enforcement, particularly in the interior under President Trump. This includes the expansion of the quote unquote priorities for immigration enforcement from the Obama administration, essentially to say things like anyone who is undocumented is fair game for immigration enforcement officers. The increase in enforcement actions at quasi-sensitive places like courthouses or outside schools. In essence, the fact that many immigrant communities are feeling like ICE, as the president said, had been unfettered to address immigration enforcement. And so their call was basically to say, this enforcement is over the top. It's not the kind of enforcement we need. It's not prioritizing serious threats. And the shorthand version of that for social media was hashtag abolish ICE. That having been said, it didn't really rise to the level of any sort of serious policy proposals. It was more of I think it has been more of a rallying cry for grassroots activism opposing President Trump policies until recently.
You're looking at this within this context that, at least for Democrats, where how this picked up. There was the upset victory from Alexandria Ocasio-Cortez over Representative Joe Crowley in the New York primaries, and she was a major proponent of this policy platform.
Right.
Her victory, aside from obviously making the Democratic establishment shudder a little bit about primary challenges, made them kind of take a look at this and going, well, is this where our base is on this issue? And so what you're seeing is now, like you said, a whole host of Democrats are embracing this position or looking into it, but we're not sure exactly what this means.
So you bring up a point about the base, and I guess that's kind of a good lead into where I wanted to go next, which is the kind of the dichotomy in what people mean when they say abolish ICE. So what do immigration advocates mean when they're saying abolish ICE?
My joke is that abolish ICE is the Rorschach test of immigration policy, which is whatever you see in it is what you think what you get out of it. And I think that what you're seeing the advocates saying is they want the agency completely eliminated. And some of them have elaborated a little bit more that the vehicle to do this would be defunding the agency. You also see advocates talking about defund hate, which is a similar parallel social media campaign that, once again, you defund ICE, you'll take care of the agency and its impact on immigrant communities. Now, with Democrats, this is where it gets a little bit more interesting, because you have some Democrats like Elizabeth Warren who are saying, let's completely eliminate the agency and then we'll come up with an alternative. That we don't know exactly what the alternative, but there will be an alternative. But then you also have individuals like Kamala Harris, who wants the agency. She wants the agency reformed. Senators Amy Klobuchar from Minnesota and Richard Blumenthal have kind of taken this a little bit further, saying, you know what, we need to have the whole system reformed in order to ensure that you have a humane enforcement system there. Otherwise, you'll still have the same players. They pointed to the administration saying, even if you reform the agency, you'll still have the administration there and you'll still have bad policies. So that's sort of where the Democrats are at least trying to formulate a response as the hashtag has become more popular on social media.
And I think you also saw recently this week with Congress back in session, Representative Mark Pocan introduced a piece of legislation that actually would abolish the agency and create a sort of commission, a bipartisan commission of congressional leadership to develop what comes next. So it's sort of a halfway point, like, yes, we'll get rid of it, but we don't know what's coming next. We'll let a group of people figure it out. I think the uncertainty of this policy right now, again, because as I said, it served as sort of a rallying cry hashtag for a grassroots movement against President Trump's enforcement policies. And frankly, it's becoming an issue for the campaign in the fall, for the 2018 campaign. The president now is, and a lot of Republicans are saying that this call to abolish ICE is Democrats' way of saying we want open borders and we don't want to see any enforcement against criminal gangs like MS-13 and the other things that ICE does. And I think that's one of the limitations of the abolish ICE hashtag movement, if you will. It's clearly directed at the immigration enforcement missions of ICE, but ICE has a lot of other missions as well, including fighting transnational criminal gangs, counterproliferation, cyber security and cyber terrorism, child pornography, violations of international copyright and intellectual property laws, all of those sort of other law enforcement missions that no one is really talking about as part of this abolish ICE movement. They're really focusing on the immigration functions of ICE.
And I think that's a great point. And Cris, you co-wrote an op-ed that was published on Monday that sort of gets into some of that as well. And so what's your take on kind of the more expansive view of what ICE does?
That's kind of the issue, is that due to the fact that the administration has really been pushing forward enforcement, that ICE has been ERO. The ERO office is the one that handles removals and detention of undocumented immigrants. And that's kind of been pushed to the fore, not just simply by the administration and their policies. Obviously, they want interior enforcement being important, but advocates are now playing a role in this too, saying ICE is really completely dedicated to the detention and removal of undocumented immigrants. But you have HSI, Homeland Security Investigation, that does these other functions. And it's interesting that this whole debate glosses over that function. It's also funny that you're seeing actually one of the other pieces of news that came out is 19 HSI agents came out and saying, they almost just say, liberate us from ICE. They actually want to have their own separate component in DHS because they feel, in their own words, they felt that they are being too closely affiliated with ICE. There was a part of this letter that they sent to Secretary Kirstjen Nielsen over at DHS, saying that we're producing these documents, but we can't co-brand them as ICE because people think we're going to be affiliated with immigration enforcement. So in a way, that's obviously their own frustrations within the agency, but I think that taking a step back, it shows for a fact that this whole debate, whether it's the administration talking about enforcement policies, whether it's the advocates who are talking about ICE as simply a racist apprehension machine, whatever they call it, really overlooks the fact that HSI does a lot of work there, and there are other components that do that.
Yeah. So how did ICE become this target of such angst among the advocate community?
Again, I think it actually probably started during the first part of the Obama administration as they were ramping up immigration enforcement. President Obama tried to target interior enforcement at that time. His slogan was felons, not families, and tried to target the ICE immigration agency more towards removal of serious criminal organizations. However, one of the ways it did so was expanding the Secure Communities program, which was this information sharing program that said when someone is arrested by local law enforcement and booked in, and that local law enforcement agency sends the fingerprints to the FBI, FBI shares those with ICE to see if ICE matches it against its immigration enforcement database. This program, although started under President George W. Bush, was expanded nationwide under President Obama and resulted in a significant uptick in the number of immigrants identified for ICE for possible deportation. Now, many of those identified did have some serious criminal records, but an awful lot of them had minor criminal infractions. And for advocates, this expansion of ICE activity, identifying other people who in their minds were sort of run-of-the-mill undocumented immigrants who weren't serious criminals, was still sort of against what they thought the Obama administration was going to support, which was legalization. I think that started the pushback against ICE. It sort of started the sanctuary cities movement, if you will, to push back against secure communities. And so I think it started there, but so that antagonism toward ICE and its interior enforcement mission and how it was conducting itself. There was also a period of time there into the initial part of the Obama administration when they were expanding immigration detention. And there were a lot of issues with how that detention was carried out. So this isn't strictly a Trump phenomenon, but I think what you're seeing is that under the Trump administration, all of these enforcement functions have been, if you will, supercharged. And that has really prompted the immigration advocacy community and frankly the immigrant community writ large to be more strongly assertive against this enforcement function. And I think that's why you're now seeing abolish ICE sort of, if you will, come out into the mainstream. And as you mentioned, the establishment Democratic leadership are now all having to try to address this issue. Is this a real policy platform? How do they want to frame it? Do they want to adopt it? Is it something that they really need for their base in the fall?
Yeah.
And what is it going to mean?
What's your sense then of how seriously we should take this demand? And what, if anything, does it say to you about the state of the debate around immigration enforcement and immigration policy right now?
Well, a couple of things. One thing I would say is that using a hashtag or some extremist rhetoric about abolishing a government agency that does enforcement may be a great rallying cry for marches and sit-ins and direct action, but it's not really a policy prescription for actual action. And so I think that Democrats are going to have to be careful on how they manage this. If they want to try to harness that energy of the base, especially for the November elections, they probably are better off not being too specific about the policy prescription behind it. At the same time, by embracing that hashtag, they do risk what the Republicans are already trying to do, being labeled as extremists on immigration. You want to get rid of all enforcement and get rid of all borders. And so some more moderate Democrats or Democrats in more swing districts and more difficult races may have to describe their response as more of a reform and refocus of ICE. So you're going to see a lot of different things. I don't think this is going to result in any serious policy movement until a couple things happen. One is we do have an appropriations process coming up. Democrats are likely to use that to try to at least make some public points in Congress about defunding parts of ICE they don't like, or using that as a platform to start talking about reforms. If Democrats are managed to take over the House in November, then I definitely would see a lot more heavy Democratic oversight over ICE, maybe some more legislative proposals about reforming the agency. But, with this president in the White House, very, very unlikely anything's going to get signed into law.
And I would just say one more thing is that taking a step back, even in terms of the debate, you can say that both sides on the immigration enforcement debate one could say they're not taking enforcement seriously, right? On the advocate side, you have these individuals who are saying, there's a whole host of hashtags, not one more, defund, hey, abolish ICE, that for them, any type of immigration enforcement is seen as evil in their own words. That they see this as a major problem. But that doesn't really acknowledge for the fact that you need immigration enforcement. There are bad actors in the United States who are here, who are non-citizens, who need to be removed from the country. So there's that component. By the same token, obviously, there's also the restrictionists who are saying, let's go full bore on immigration enforcement. And as we've seen with family separations, when you start going down that path, you're going to have some pretty bad outcomes. So I think it's once again, I think both sides need to sort of look at enforcement and go, where can you have a reasonable discussion on what really an enforcement system should look like, how it should operate, and its key goals. But saying no deportations at all, or let's defund this agency, I don't think gets us there.
Thanks, Cris. Thanks, Theresa. Turning now to the continuing story of family separations and the court-mandated efforts to reunite those families. So last month, a federal court ordered the Trump administration to begin reuniting families that it had separated as part of the zero tolerance policy. Let's start with what exactly the court told the administration it needed to do with these children.
Sure. So it was a district judge in San Diego who said that The administration needed to reunite all children under 5 years old with their parents within essentially a 2-week period that's due this week. So the parties, the Justice Department, Health and Human Services, which has custody or responsibility for the children, the minor children, and the advocate, ACLU is the lead plaintiff in this case, met with a judge over the weekend. They went over the statistics. HHS says they have 102 children in their custody that meet this under 5 requirement, and they have managed to reunite or will have managed to reunite by the deadline, maybe a third of them. They did describe the status of all the rest. Many of the parents are undergoing background checks. The agency wants to make sure that they don't have a criminal background. Some of them are undergoing DNA checks to make sure they really are parents or related family to the children. So there is a process in place, and it seems like the parties are trying to work together, but the judge has stuck to that deadline, wants to ensure that they're in place. The remainder of the children that are minors, but above 5 years old, have until later in July to be reunited with their parents. Now, one interesting issue is that been uncovered in this process is that DHS has admitted that some 20 children's parents have already been deported. And so that's a different category of what to do to try and reunite this set of parents that have already been deported without their children.
So you alluded to this in your response just now, that there was a deadline of July 10th to reunite kids under age 5 with their parents, and you alluded to the fact that they haven't met that goal. What are they saying to the court about why they didn't meet the goal, and how long do we think it's going to take?
What they've said to the court is that there's multiple reasons for the delay. One of the reasons is just identifying the children and the parents. They're in 2 different systems. DHS has the information about the parents. HHS has the information about the children. They didn't necessarily link that information up at the time both agencies took custody, and so now they're trying to to relink that up. The second piece is the process that HHS has instituted to do background checks of the people to whom they're releasing children. Even in this case where they are alleging that they are the parents, they want to make sure that the parents are not somehow going to be a danger to kids. And what HHS is saying is that already in some of the background checks they have done, they have found some parents who have had accusations or have been charged with child abuse or endangerment. And so they are concerned about, even if it's a family member, releasing the child into that custody, or the parent has a significant criminal charge against them, not just the immigration charge under zero tolerance, but another criminal charge that renders them not necessarily the best place for that child to be. That's one of the issues that the government is saying, is that we want to make sure that we're putting people in care of parents who are actually going to take care of them. Now, the judge in the case has said, look, you don't have to do every single background check you're required to do under the statute relating to unaccompanied children, because these people did arrive with adults. You could find a streamlined way to do this, and you should do so. And so the government agencies are working with this. One thing I would say that's interesting is, although the ACLU brought this lawsuit and challenged all of this, they are now working with the government agencies to try to identify parents, to try to identify children, to bring the information together, even while maintaining with the judge that the deadlines should stay in place. But they are trying to be helpful in helping the government agencies reunite the parents with the kids. And I think part of that is that while they probably could get some political advantage in bashing the government for not having met the deadline, their vested interest is in seeing the families reunited, and that's where they're working.
So you mentioned a little bit about the process that HHS has to go through to try to identify people. What is making it so difficult, ultimately, for the government to reunite kids and families? What are the hurdles here?
So probably the biggest hurdle is that when this policy was put in place, it was put in place as a policy proposal by, frankly, cabinet-level departments in the White House. But it was not done after consulting with the operators whose job it is to carry all this out as to what the challenges might be. And you had 2 different systems that existed. So you had the DHS system of prosecutions of adults, of dealing with criminal adults, of detention of adults. And then you had the Health and Human Services Agency that dealt primarily, their system was primarily for kids who arrived without parents, unaccompanied children. And their role is to protect them, to care for them until they can find another adult in the United States to take care of that child. But there was no question that there was a parent they were trying to be reunited with. These were unaccompanied children. What the government's zero tolerance policy did was create unaccompanied children from accompanied children, from family units. And HHS didn't have a process to track children who had arrived with an adult. Their whole entire system was designed for children who had arrived without an adult. So you had a system that wasn't set up to match adults and children back together, because that wasn't how it was created. It wasn't what it was created for. And you have a system of adult detention that was not created for adults who had kids that weren't with them. So these two systems were not set up to do a later matching. They're trying to ad hoc it now. But because none of this was basically thought out before the policy was put in place, they're now retroactively trying to very quickly, in an emergency situation, figure out how to do this. And I think an awful lot of government officials who are doing their best to try to do something on a very quick turnaround. As I mentioned, the advocates organizations are trying to help with this as well. But this is the result of a policy being put forward without due consideration for all of the operational impacts down the line.
And one more thing to add with that is, because of lack of planning foresight, the government has only so much capacity to be able to detain these families. And as we've talked about in this podcast, there's also the Flores settlement, a legal agreement that says you can't hold children in detention for more than 20 days. So in addition to the fact that you have these two systems and it's difficult to pair up individuals in them, you also have the broader concerns about, do we have enough space to keep these families together? Can we legally keep these families together? And the answer to that is the government doesn't have that capacity, and they don't have that legal authority to do that. So once again, it's just a lack of foresight. There's an old saying, fail to plan, plan to fail. And I think that that's a really good way of summarizing what's been happening with this policy and the outcomes of it.
Yeah. I would just mention on the Flores settlement, the judge in the Flores settlement, Dolly G, DOJ filed a motion with her to allow for extended family detention as a way of keeping families together.
And just to clarify, this is the limit of number of days on which a minor can be kept.
Yes, under the Flores settlement. Department of Justice filed a motion to basically grant exemption to allow them to continue to detain families. The judge denied that pretty clearly and unequivocally, said that the legal arguments were basically not very good at all, and said no. Interestingly, the government then said, okay, if that is your decision, then we will these parents have two options. They can waive the Flores rights of their child and agree to have them detained with them in detention, or they can agree to let their child go off in the HHS system and be separated. The plaintiffs in the Flores case, unfortunately, were put in the position of having to agree with that because the Flores settlement did not grant any rights of the parent to be released from detention. So if the government is required to either mandatorily detain the adult or wishes by reason of policy to detain the adult, that would be the choice, is that the parent would have to waive the Flores rights of the child so that they could be detained, or allow the child to be detained, to be put into HHS. This is going to be a very hard decision if that's the forced decision that the administration is making parents take. The judge rejected, however, that was somehow difficult because they said the government always has the option to release the parent. And so what we're hearing now is that Immigration Customs Enforcement is going to be releasing most of these parents with an alternative to detention, an ankle bracelet or some sort of management custody, so that they can reunite with their parents, which means we are back to the issue that this whole policy was trying to end, which is so-called catch and release. Yeah.
I'm sure we'll get into those alternatives in a future episode. This conversation isn't one that's going to resolve itself quickly.
Nice.
Thanks, Theresa. Thanks, Cris. Finally today, denaturalization. In other words, when can the government revoke someone's citizenship? And Tim O'Shea is here. And Tim, you wrote a blog post on this topic recently, and you note that the government has been stepping up its investigations of possible immigration frauds. What's going on here?
So this past June, USCIS announced that they would be opening an entire new office in Los Angeles to investigate people who may have cheated the immigration system with the intention of finding evidence that the Department of Justice could use to try and remove those individual citizenship. These cases were previously handled out of a small pop-up office in LA, but now they're being given dozens of agents and many more resources to pursue those cases.
So why is the government choosing to make this push on revoking citizenship or investigating possible fraud now? And are there particular groups of people that they're targeting with these efforts?
Yes. So the administration is vastly expanding its use of denaturalization in an effort to combat immigration fraud and what they call cheating the system. A lot of this impetus stems from a specific initiative. So USCIS has been digitizing old fingerprint records from deportations to find matches with later immigration applications. That could reveal possible perpetrators of fraud who were supposed to be deported and then reapplied under different names to evade consequences. That initiative started in September 2016, but it's just now coming to fruition with the names of possible people that could be investigated. Some of these new cases also stem from just review of files and seeking cases that they wouldn't have pursued under previous administrations. So the DOJ is also seeking to remove the citizenship of a convicted terrorist who's been behind bars since 2003. And there was also a bill introduced to the House of Representatives by Representative Lee Zeldin that would make gang membership grounds for denaturalization in an effort to curtail people who cheated the immigration system in order to enter the United States and join gangs.
So you mentioned some of the ways, but are there other ways that might cause, other things that might cause somebody to lose their citizenship?
Yeah. So for the past 30 years, denaturalization was quite rare. For instance, people could be denaturalized if they served in the military of a country fighting the United States. These newer cases revolve mainly around immigration applications themselves. The forms that you fill out when applying for a change of immigration status contain many questions about a person's background, especially their criminal history and immigration history with the United States. If someone lies about past convictions, crimes, deportations, or anything like that, then they could have that immigration status, including citizenship, taken away if the government discovers they were lying. That's why the fingerprint initiative is causing so many more cases. The fingerprints are revealing people who tried to hide past immigration or criminal violations when they applied for new status. The biggest constraint on those false statements is that the Supreme Court ruled last year that false statements provided for a change of immigration status, for them to be grounds for future revoking of that status, have to have been essentially a determining factor. So if you told a lie not to hide something from your past, but just out of embarrassment or desire for privacy, then the Supreme Court ruled, then those types of lies can't be grounds for taking that immigration status away later on.
So how does the process of losing one's citizenship work? How can the government do this?
The government essentially takes someone to court and tries to convince a judge that they deserve to be denaturalized. The government argues in front of a federal judge that the defendant committed the act that would trigger their loss of citizenship. In most of these cases, that means the government proving that a person provided a false statement on an immigration application with the intention of avoiding admitting to something that would harm their application. Most of these cases are civil denaturalization cases, which means not only that they don't have a statute of limitations, but also that the defendants are not entitled to a legal defense. So you can't get something like a public defender for a civil denaturalization case. If someone loses that case, then they're reverted back to their previous immigration status, which is usually a green card. This means they're not automatically subject to deportation proceedings, but that is the next logical step for the government, and they often take that step.
Thanks, Tim. And that's our show for this week. Thanks to all of you for listening, and a special thanks to our producer, Emily Schrader. Please take a second to find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_bipartisan. And once again, don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. Just search Bipartisan Policy Center. Join us again next time.